Hello viewers, welcome to the Bachelor course of Population Studies. Today we will discuss legislations on population in India. Worldwide, every second 5 people are born and 2 people die, leaving 3 more humans to inhabit the earth. How long can Mother Earth provide for this? Currently, the world population is around 7.2 billion and grows by 80 million a year. The Global Footprint Network estimates that we are already overusing planetary resources. In terms of renewable resources and the Earth's capacity to absorb carbon, toxic chemicals and other forms of pollution, we will need 2 Earths by 2030 to sustain us. Our current growth path is unsustainable. The warning signs are all around us as rivers and lakes shrink, water tables fall, carbon emissions rise, deserts expand, forests shrink and fisheries collapse. India does not promote polygamy. Despite India's best efforts, the population continues to grow at a present rate of 1.8%. During 2016, India's population is projected to increase by 16 million people and reach 1.33 billion in the beginning of 2017. The Government of India has enacted various laws and framed various policies with regard to different aspects of its population. Some of these legislations are Prohibition of Child Marriage Act 2006, replacing the Child Marriage Restraint Act 1929, the Census Act 1948, the Citizenship Act 1955, the Compulsory Registration of Birth and Death Act 1969, the Medical Termination of Pregnancy Act 1971, Pre-Conception and Pre-Natal Diagnostic Techniques Act 1994 and other legislations relating to sterilisation, abortion and contraception. Various acts adopted by Indian governments are: number 1, Child Marriage Restraint Act 1929. Child marriage is an age-old practice that has both social and religious sanction and cuts across all sections of society. Recognizing child marriage as a social evil, the Child Marriage Restraint Act 1929, popularly known as the Sharda Act, was passed to prohibit the child marriage. Originally, the age limit for a male was 18 years and for a female 14 years. The age limit was subsequently raised in the case of females from 14 to 15 by amending the Act of 1949. Violation of the provisions of the Act was made punishable. This law applied to all citizens of India. In 1978, the law was amended to make it more effective and raise the minimum age of marriage by 3 years, that is from 15 to 18 years in case of girls and from 18 to 21 years in case of boys. However, despite the law, child marriages continue to take place. There were many marriages in which both the girl and the boy were children. In others, the girls were children or minors who were married off to much older men. In yet another attempt to deal with the problem, the government passed the Prohibition of Child Marriage Act 2006. This act was notified on January 10, 2007 to overcome the constraints of the former legislations in effectively dealing with the problems of child marriages in India. It came into force on 1st November 2007. The Prohibition of Child Marriage Act 2006 under Section 11 provides punishment for those who permit and promote child marriages. It is necessary that every individual who is aware of any child marriage that is going to be conducted must report about it to the authorities otherwise he or she will be held liable under the present law and also the Indian Penal Code for abetting the offence. Now, where does this Act applies? It applies to all citizens of India irrespective of religion. It, however, does not apply to the state of Jammu and Kashmir. It excludes the residents of the Union Territory of Pondicherry from its application. For them, the French civil laws are applicable as they are treated as citizens of France. Now, what does this law provide for? The basic principle of the law is, number 1, to make a child go through a marriage is an offence. Second, child or minor is a person up to 18 years in case of girls and 21 years in the case of boys. The provision of this law can be classified into 3 broad categories. Number 1, prevention, protection, prosecution of offenders. The next law is Census Act 1948. The decennial census of India has been conducted 15 times as of 2011. It has been conducted every 10 years beginning in 1871. Post 1961, it has been conducted by the Registrar General and Census Commissioner of India. All the censuses since 1951 are conducted under 1948 Census of India Act. Legal provisions of Census Act 1948 and Census Rules 1990. Enumerator or supervisor is appointed under this Act. All census officers are appointed under section 4 of the Act. Now, the obligation of the census officers or staff: they cannot refuse duty, they cannot obstruct anyone from performing duty, cannot put offensive, improper or unauthorized questions, they cannot knowingly make a false return, they cannot disclose any census information. Now, the rights of an enumerator. The rights of the enumerator are: number 1, to enter house, enclosure, vessel or any other place, to paint or affix numbers on the building or census house, to ask all such questions as printed in the census schedules, to obtain the answers from respondents. Now, the penalties are imprisonment up to 3 years and fine up to rupees 1000, that is under section 11 of the Act, for refusing to perform duty, putting offensive or improper questions, disclosing any information. Other provisions are under section 15A of the Act. Number 1, service interest of the members of the census staff are given due protection. Second, census duty is considered as on duty. Now, under section 15B of the Act, any act undertaken in good faith by the census staff under the Census Act and rules is protected. Obligation of the public, section 8 or 9 of the Act, to allow entry to the census staff in his or her house, to allow painting of number on his or her house, to give correct information to the best of his or her knowledge and belief. Now, the punishment for violation: fine up to rupees 1000, this is under section 11 of the Act. The next Act is Citizenship Act 1955. The Citizenship Act 1955 defines the concept of Indian citizenship and lists ways to acquire it, explicitly denying citizenship to all undocumented migrants, persons domiciled in the territory of India as on 26 November 1949 automatically became Indian citizens by virtue of operation of the relevant provisions of the Indian Constitution coming into force. Most of these constitutional provisions came into force on 26 January 1950. The Constitution of India also made provisions regarding citizenship for migrants from the territories of Pakistan, which had been part of India before partition. The Citizenship Amendment Bill 2015. The Citizenship Amendment Bill 2015 was introduced in Lok Sabha by the Minister of State, Ministry of Home Affairs on February 27, 2015. The Citizenship Act 1955 regulates the acquisition and determination of citizenship after commencement of the Constitution. It provides for citizenship by birth, descent, registration, naturalization and by incorporation of territory. Now the next is Registration of Birth and Death Act 1969. The history of civil registration in India dates back to the middle of the 19th century. It started with the registration of deaths with a view to introducing sanitary reforms for control of epidemics and diseases and not so much for studying population trends. Against this background, a central legislation on the subject was considered absolutely necessary to bring about improvement in the system. The Registration of Birth and Death Bill was introduced in the Rajya Sabha in 1964, which was passed in the budget session of 1964-65 but lapsed on the dissolution of the parliament. The bill was again passed by the Rajya Sabha on February 27, 1968. The Lok Sabha passed the bill on 27th May 1969 with certain amendments. These amendments were approved by the Rajya Sabha on May 16, 1969. The bill was passed by both houses of parliament and received the assent of the President on May 31, 1969. It was notified in the Gazette of India on June 2, 1969. As per provisions of the Registration of Birth and Death Act 1969, registration of every birth and death is compulsory. The persons who are responsible are to report the events of birth and deaths to their nearest registration units within 21 days of occurrence of such events, failing which late fees for delayed registration are charged. This Act provides for uniform law across the country on the registration of birth and deaths, compulsory reporting and registration of all births and deaths. Implementation of the Act is the responsibility of the state governments. Rules framed by the state governments are based on a model set of rules provided by the central government. The persons responsible for doing births and deaths registration are area-wise birth and death registrars, village panchayat, village administrative officers, town panchayat, sanitary inspector executive officers, corporate or municipal areas, sanitary inspectors of the division, plantation estates, estate manager or plantation manager. Next Act is Medical Termination of Pregnancy Act 1971. Medical Termination of Pregnancy Act 1971 extends to the whole of India except the state of Jammu and Kashmir. Aims of the Medical Termination of Pregnancy Act are: Medical Termination of Pregnancy Act is an enabling act which aims to improve the maternal health scenario, legalize abortion services, promotes access to safe abortion services to women, decriminalizes the abortion seeker, protection to medical practitioners who otherwise would be penalized under the Indian Penal Code. Legal framework of Medical Termination of Pregnancy Act. Medical Termination of Pregnancy Act, Medical Termination of Pregnancy Rules, Medical Termination of Pregnancy Regulations. Next Act is Preconception and Prenatal Diagnostic Technique Act 1994. Preconception and Pre-Natal Diagnostic Technique Act 1994 is an act of the Parliament of India enacted to stop female feticide and arrest the declining sex ratio in India. The act banned parental sex determination. This process began in the early 1990s when ultrasound techniques gained widespread use in India. There was a tendency for families to continuously produce children until a male child was born. Fetal sex determination and sex selective abortion by medical professionals have today grown into a ₹1,000 crore industry. Social discrimination against women and a preference for sons have promoted female feticide in various forms, skewing the sex ratio of the country towards men. Objectives: the main purpose of enacting this act is to ban the use of sex selection techniques after conception and prevent the misuse of prenatal diagnostic techniques for sex selective abortion. The main features: offences under this act includes conducting or helping in the conduct of prenatal diagnostic technique in the unregistered units. Main provisions in the act are: the act provides for the prohibition of sex selection before or after conception. It regulates the use of prenatal diagnostic techniques like ultrasound etc. by allowing them their use only to detect body disorders. No laboratory or center or clinic will conduct any test including ultrasonography for the purpose of determining the sex of the fetus. No person, including the one who is conducting the procedure as per the law, will communicate the sex of the fetus to the pregnant woman or her relatives by words, signs or any other method. Any person who puts an advertisement for prenatal and preconception sex determination facilities can be imprisoned for up to 3 years and fined ₹10,000. Compulsory registration. The Act mandates compulsory registration of all diagnostic laboratories, all genetic counseling centers, genetic laboratories, genetic clinics and ultrasound clinics. Amendment in 2003. Pre-Natal Diagnostic Technique Act 1994 was amended in 2003 to the Preconception and Pre-Natal Diagnostic Technique Act to improve the regulation of the technology used in sex selection. Implications of the amendment. Amendment of the Act mainly covered bringing the technique of preconception sex selection within the ambit of the Act, bringing ultrasound within its ambit, empowering the Central Supervisory Board constitution of the state level supervisory board, provision for more stringent punishments, empowering appropriate authorities with the power of the civil code for search, seizure and sealing the machines and equipment of the violators, regulating the sale of the ultrasound machines only to registered bodies. Legislations relating to sterilization and contraception. The sterilization program was initiated in India's Family Welfare Program in 1956, starting with a low tempo in the earlier years. Later on, it became popular method of family planning. The government has established various central laparoscopic training centers in different parts of the country. Training in laparoscopic sterilization techniques is imparted by reputed and experienced gynecologists. The minimum educational qualifications required by the doctor for this training program are MD Gynae or MS General Surgery or MBBS with DGO having worked for a minimum period of 3 years in a government hospital or any other medical institution. This training is of 2 weeks duration. The government has modified the earlier compensation scheme for sterilization and has increased the payment to compensate for loss of wages to those accepting sterilization. Government introduced a national family planning insurance scheme which provides compensation to sterilization acceptors as well as to provide indemnity insurance to the provider against failures, complications and death following sterilization. These measures are introduced as confidence building mechanism among the family planning clients. The policy of the Government of India is to induce more eligible couples to adopt contraceptives for family planning. In pursuance of this policy advice, facilities and services are provided free of charge to help eligible couples for planning their families. Services are provided through medical and paramedical staff. A cafeteria approach is followed whereby eligible couples may select any contraceptive of their choice offered in the National Family Welfare Program. Department of Family Welfare has been procuring condoms with effect from 1994-95. Under the free distribution scheme, condoms are made available to acceptors free of charge. This scheme also meets the requirements of condoms by states or UTs under the STD or AIDS control program. The scheme of social marketing of oral pills was launched in 1987. The brand name Maladi has been given to the product under social marketing program. Voluntary organizations working in the field of health and family welfare and social marketing companies are also allowed to sell oral pills in their own brand name under the program. These branded products are sold at prices fixed by the concerned marketing organization in such a way that these prices are less than the prices of commercially sold brands, but not less than the retail prices of Maladi. Department of Family Welfare has undertaken advertisement campaign for promotion of Maladi on television, radio, newspaper and magazines. In order to encourage distribution companies, a scheme for providing incentive has been introduced with effect from 1st October 1996. Weekly oral contraceptive pills Saheli and Santhron are being manufactured and marketed by a public sector undertaking and a private sector company. A national center for testing of intrauterine device and tubal rings was set up by Department of Family Welfare at the Biomedical Engineering Wing at IIT New Delhi in 1988-89. With effect from April 1992, the center is being funded entirely by Government of India. To sum up, it can be stated that India has a long history of addressing population issues through policy and programs which have not been able to yield the desired results. In the world today, India ranks second in population numbers. Very soon, India is set to overtake China, which at present is most populous country in the world. There is an important legal aspect of population phenomena and family planning which has not been sufficiently explored so far. Indian legal regime could not systematically compile all of its laws bearing on family planning. The various statute, administrative guidelines and judicial pronouncements are often scattered throughout the general body of law. The significance of law to facilitate family planning lies in helping the state to secure constitutional guarantee of socio-economic justice to the people of India. The legislations or acts passed by Government of India so far does not have a direct bearing on the birth control. In the present scenario, of ever increasing population, India needs most stringent laws to check its population growth. Further, these laws need to be supplemented by the efforts of the other stakeholders like NGOs and general public, etc. That is all for today. In next lecture, we will continue with some related issue. Thank you.